I have your announcement for the record, please, Mr. Bankston.
Sure. Mark Bankston appearing for all of the plaintiffs in this matter.
All right, and Mr. Reeves?
Brad Reeves for the defendants in all these matters.
All right. So, Mr. Bankston and Mr. Reeves, we had a brief conversation about what we are going to cover today. And now that we're on the record, we're going to go ahead and get started. Mr. Bankston, all of the motions today are yours. Do you have a preference on what order you would like to take them?
Well, actually, Your Honor, I kind of figured for convenience and efficiency's sake, we do a presentation that kind of brings up the histories of the cases. And because these discovery disputes kind of weave in and out of each other, I was planning to kind of deal with them collectively.
All right,
So
I
that
think
way I
that's
wouldn't
fine.
do the same material over and over again.
Yeah, I noticed a lot of overlap reading the briefs getting ready for today. So that I think is an excellent suggestion. And I'm ready when you are.
Okay. Your Honor, I'm going to share my screen if that's
Yes,
okay.
please.
And I'm going to minimize these windows here so I can see. All right. So, Your Honor, as you know, we're going to be covering all four cases. And I think there's no better place than to start than the beginning. So the first thing that we are going to do, right, there we go. All right. Your Honor, the first case that we're dealing with today is Heslin v. Jones. This was the defamation case involving InfoWars allegations that Mr. Heslin was lying about holding his dead child after Sandy Hook. Mr. Heslin had appeared on Megyn Kelly's show to push back against Mr. Jones' allegations that this entire incident was fake. After he did that, he was retaliated against when they said that he was lying about having held his son. That case was brought back in 2018. And in fact, a discovery order was entered on August 31st, 2018. So it's sort of happy third birthday to our discovery order in this case. That order, which to this date has never been responded to in any way, shape, or form, required written discovery and deposition of all the defendants, about 30 pages of written discovery, and then for each of the four defendants. And the defendants refused to respond to that discovery. And actually, it's correct to say they did respond, but their responses simply said, the court does not have the authority to order us to answer this discovery, so we're not going to do it. So they basically just told the court to pound sand. We immediately filed a motion for contempt, being very alarmed with that. They appealed the following day. So for a moment, let's stick a pin in Mr. Heslin's case, that second motion for contempt, because that went up on appeal. And that brings us to our next case, which is Lewis versus Jones. Mrs. Lewis is the co-parent with Mr. Heslin of Jesse Lewis, a victim of Sandy Hook. Mrs. Lewis brought her suit a little bit later. Her suit alleges intentional infliction of emotional distress because InfoWars made false statements about the circumstances of the death of her child. In that case, the court likewise entered discovery orders on January 25th and March 8th, 2019. That also required written discovery and deposition of all the defendants. The defendants refused to respond to that discovery. They did show up for deposition, but they failed to prepare their corporate representative for the companies. That was Rob Dew. And as noted by the court during the hearing, it was a completely useless deposition. Mr. Dew did not have any idea what he was supposed to be talking about, had no idea he was supposed to prepare for the deposition, and basically answered, I don't know, to every single question. We filed a motion for sanctions. On the eve of that hearing, the defendant provided a document dump filled with non-responsive materials. And we'll talk a little bit more about those materials in a bit here. But for the moment, we can just say everybody at that moment was in agreement that this discovery production was a mess. Defendant's counsel during that hearing begged the court not to enter actual sanctions on the record and instead said that he would agree to privately pay $8,000 in attorney's fees and surrendered his client's TCPA motion except for a single legal issue. They wanted to argue, the only thing they wanted to argue was that Mrs. Lewis could not bring a claim if she had not been personally identified. And we knew this argument was bunk because, for instance, when Natalie Holloway disappeared in Aruba, her mother, Elizabeth Holloway, was able to sue the National Enquirer when the National Enquirer made false statements about her daughter's disappearance. So we knew the identification of the plaintiff wasn't an issue, so we agreed to forego the component of the motion seeking to strike the TCPA motion because we knew we had it in the bag by then. Those appeals actually turned out to be a little bit differently, so we aren't going to be accepting those kind of stipulations in the future. But for the moment, that's what happened there, and discovery was still a very big mess. What happened next in the chain of events is actually the Connecticut case was part of the same process. As you know, that there is a different group of parents who are suing in Connecticut. They are undergoing exactly the same kind of anti-SLAPP process, except Connecticut's deadlines on that are a little more generous. So they were actually going a little bit after the Lewis case. So once the Lewis case happened and that discovery problem, we then had the discovery problems in Lafferty. And these become relevant to our cases a little bit later. What had happened there is that by March 2019, the defendants had violated numerous discovery orders. And this is the Connecticut Supreme Court kind of summarizing what happened in that case. Defendants' local counsel at that time, this is March and April, started saying that he was in an ethically ambiguous position and he could not discharge his obligations on the pending discovery orders in a way that would permit him to put his signature to a document. He said the discovery situation is a mess right now. That's Exhibit 5 to our brief. Judge Bellis gave one final extension, and then defendants produced a dozen files of child pornography. Plaintiffs' counsel in Connecticut informed the FBI, my counterpart Chris Maddie up there. And after InfoWars was informed, Jones appeared on his show and threatened plaintiffs' counsel. I mean, none of this was public at this point. This was Jones making it public. Jones called plaintiffs' counsel gang members, offered a bounty on their heads. And you have to remember that to Jones, all of us are one big group. We're a conspiracy of Democratic operative lawyers who have been recruited and by his words, by George Soros and put on payroll. And Hillary Clinton is directing us. And we're the people he's coming after. Specifically in this video too, he was threatening Chris Maddie directly. Now, what I want to show you now, Your Honor, this is our plaintiff's hearing Exhibit 1. This is a video clip from April 2019. This was actually admitted and played in court in our last hearing in this case, in December 20th, 2019, the sort of hearing that we're continuing right now. So this has already been admitted and is part of the record, but I'm going to offer it now because I want to play a video for you of what Jones said right after all of that happened.
All right.
Also, I should warn this for folks who are on the live stream. This video I'm about to play is extremely not safe for work. It has a lot of profanity in it. Also, even if you're okay with the profanity, if you have children in the room, this video gets a little frightening at points. So I just wanted to warn the live stream people.
Thank you.
You think when you call up, oh, we'll protect you. We found the child porn. I like women with big, giant tits and big asses. I don't like kids like you goddamn rapists, F-heads. In fact, like this, you fucks are gonna get it, you fucking child molesters. I'll fucking get you, man, fucks. Now we're done right there. I know I should have deleted the radio. Probably someone else. I don't care. You're trying to set me up with child porn. I'm gonna get your ass $1 million. $1 million, you little gang member. $1 million to put your head on a pike. $1 million, bitch. I'm gonna get your ass. You understand me now? You're not gonna ever defeat Texas, you sacks of shit. So you get ready for that. Now, I don't usually use French, but I'm pissed right now. Out of hundreds of thousands of emails they got, and they know right where to go. What a nice group of Democrats. How surprising. What nice people. Chris and Maddie. Chris and Maddie. Let's zoom in on Chris and Maddie. Oh, nice little Chris and Maddie. What a good American. What a good boy. You think you'll put on me? Anyways, I'm done. Total war. You want it, you got it. I'm not into kids like your Democratic Party, you cocksuckers. So get ready. You little white shoe boy jerk off. Son of a bitch. I can't handle if they want war. They're gonna get war. I am sick of these people. They bunch of chicken craps that have taken this country over and want to attack real Americans. If you want blood, you got it. Blood on the streets, man. I mean, I am not going to sit here in my life and have these dirtbags say that I've done these things I haven't done and then know where to go and weasel in and find this perfect thing. It's ridiculous how obvious it is. You think I'd roll over and spray crap out my ass and show my belly and piss on myself to bow down to you? You just summoned war. So get ready. And I'm just asking the Pentagon and the Patriots that are left, and 4chan and 8chan and Anonymous, anybody that's a Patriot, I just have faith in you. I'm under attack, and I summon the me war. I summon all of it against the enemy. I will never sell out to these people. Anyways, want to make some closing comments?
Okay, so that is what Mr. Jones said. Obviously, that was very, very disturbing to us. Right after that, Judge Bellis assessed sanctions and struck InfoWars' motion to dismiss. She cited the production of child pornography, the despicable, potentially criminal threats. There was also a fraudulent affidavit submitted up there in Connecticut that was not actually signed by Mr. Jones. But the court said even if you ignore all of that, which is completely unprecedented, there were still multiple failures to comply with these discovery deadlines. Defendants would not fairly comply with their discovery obligations. Judge Bellis said at that time that she wasn't going to grant a default, but if there is continued obfuscation and delay and tactics like I've seen up to this point, I will not hesitate after a hearing and an opportunity to be heard to default the Alex Jones defendants if they from this point forward continue with their behavior with respect to discovery. You can see that in Exhibit 6. The next thing that happened was Heslin versus Jones comes back to Texas. As you remember, that case had gone up on appeal after they refused to answer discovery, and we had brought in a motion for contempt. That was dismissed on August 30th, 2019. For the next month, InfoWars did absolutely nothing, just like they've done in this case, actually. Judge Jenkins then held a hearing on October 3rd, 2019. And you can see from that hearing, he is extremely puzzled why, after everything that's happened in this case, these defendants are still refusing to respond to discovery and will not obey his orders. Now, I'm sure you know Judge Jenkins, him being one of the more senior judges in these, this last generation. And lawyers around here will tell you, you do not get sanctions from Judge Jenkins. Judge Jenkins, I think to his credit, is a judge who vigorously pursues conciliatory actions and tries to work things out and really wants to give people a chance. He didn't sanction immediately in the Lewis case. The idea of Judge Jenkins granting a contempt sanction and a $25,000 fine is pretty extreme to most people in this courthouse. I haven't found anybody who's ever heard of it happening. But at that point, he was upset and went ahead and granted the motion and granted us our attorney's fees. They had another chance to comply because right at the same time that had happened, Mr. Heslin's claim for intentional affliction for emotional distress came for a hearing on expedited discovery. And once again, for now again in Mr. Heslin's case, Judge Jenkins ordered discovery for the claim for the IED claim. That discovery order was entered on October 18th, 2019. That required written discovery and depositions of Jones, Free Speech Systems, and their chief editor, Paul Watson. So let's talk about what happened there. First, the defendants gave false and evasive answers to discovery. And what you need to understand, as you see from our exhibits in here, the written discovery that was served in the court's discovery order is very simple stuff. It is very simple. It's stuff like identify all the videos about Sandy Hook, identify all the employees who were involved in those videos, identify for every statement, here's 17 statements you made about Sandy Hook, identify your source of those statements, identify the methods of communication that you used in the office. All of them were not answered. They were given answers. It would be things like our sources were newspapers and things we found on the internet. When they asked who was involved in these episodes, Alex Jones and Rob Dew and maybe some other people. We don't know. We can't figure it out. They would never tell me what videos there are. Any of the most basic information in interrogatories and requests for production, completely evaded. They failed to prepare Mr. Dew again. And this is what's really shocking. Judge Jenkins was clearly shocked by this, that the exact same deponent who was vigorously chewed out about not being prepared, they show up again and perform the same mockery of the deposition again. In fact, of both depositions. They failed to remedy the document production. And we're going to talk about this a little bit later. There's some really alarming testimony about what has and hasn't been produced in this case, and that there should be a lot more production that has not happened. And that was confirmed in some of those depositions. And those depositions also revealed other alarming irregularities. We know that there was no no litigation hold put out in this case. There was never until 2019 was there any communication with Inside InfoWars to tell people to preserve documents. And at that point, they just sent an email to every employee saying, hey, if you have any documents, collect them and bring them to us. Nobody actually went and searched or monitored any of this. The very employees who may have been giving the most damning testimony were told to go look for documents on their own files. And what happened? Not a single employee returned a single document. The defendants also failed to produce crucial evidence. And this is at the heart of it is mostly the videos that are at the heart of plaintiff's claim, which we don't yet have. As you know from the briefing, very soon after we sued, all of their videos started being taken down off of line. So none of them are publicly available like they used to be. And InfoWars has made, at this point, our best estimate is over 100 videos on Sandy Hook. We didn't have that. And of course, we also don't have their social media evidence. One thing that the briefing gives you a flavor for is all those things. I don't think the briefing quite gives you a flavor for how evasive Mr. Jones was on these issues, on things like his sources and identifying those in interrogatories, or the methods of communication, or the videos, any of it. And so I want to show you just about 10 minutes from Mr. Jones' November 2019 deposition, because I do think it gives you a flavor of the bad faith we've seen in this case. And this is plaintiff's hearing exhibit number 2, which I'm going to play now.
So ambulances came an hour and a half later. That's not true, right?
I don't have the timeline in front of me.
Are you going to claim in this lawsuit that those ambulances came an hour and a half later?
I'm gonna have to check that.
Well, I asked you to check it. Did you? I asked you in discovery to check it. Did you?
I'm going from memory. I believe there's some conflicting reports.
I'm not asking what your memory was. I'm asking if you checked it.
I think I did check it. I don't.
What were the results of you checking it?
I don't have that in front of me.
And whatever it was, you didn't give it to me either, right? In discovery?
Oh.
Correct?
Oh, I thought that was rhetorical.
No, I don't ask rhetorical questions, Mr. Jones. I want testimony.
Oh, I don't have that in front of me. I can't speak accurately to that. Okay, what was the question?
The question is, you said right after that, the Wayback Machine discussion, you said the word is that school was shut down for those years. That's what the records show. That was your argument, correct?
I'm specifically talking about the other articles I was talking about, yes.
That's what I'm asking you about right now.
Mhm.
Those records, what are you talking about?
I'd have to go pull them up.
And you haven't done that.
No, not recently.
You've been under lawsuit now for over a year on Sandy Hook related cases, multiple cases, and you haven't done anything to go try to find what your sources for these claims are, have you?
I've done a lot of work.
Well, you were asked in interrogatories, weren't you, to identify your sources for all your Sandy Hook claims, including this one? You were asked that, right?
I don't remember.
Okay. You don't remember saying you couldn't figure out what your sources were? Is that what you're saying?
I don't understand.
Let's just ask you right now. Are you able to figure out what your sources are?
Yes, I could specifically, I mean, now that I understand what you're asking, I could go find that.
So if I wanted to know, when you say the records show that the school was closed down, you could produce those records.
I could show what I was talking about at that point.
Yeah, or you could produce whatever you were relying on as your source, right?
Now that you've specified,
You haven't done that though, have you?
I don't have a law degree.
Okay. If you were asked the question, produce to me your source or records or information that you relied on to say the school was closed, that's something you could do.
Yes. I don't know if it would be what you're looking for. We had.
Let's talk about that Bloomberg email that comes up. This idea that there was an email sent the day before Sandy Hook saying, get ready, next 24 hours, there's going to be a big event. That email, you've been asked for that email, and you say you don't have it, right?
We were covering reports of the email that was sent out to the activist groups that had been in the news.
Where were you covering it? What do you mean, were you covering it?
We were covering the reports of them activating their anti-gun rights organization.
Okay, well, see, here's the thing, Mr. Jones. At first, I thought there must be some email coincidentally sent on the day before Sandy Hook that Bloomberg or his people sent that you must be willfully misinterpreting or something like that. But the problem is nobody who's looked at this has been able to find any evidence that such an email has ever existed. And I want to know if you can explain that.
Well, I'm just not taking your assertion that that's the case.
Well, that's why I've asked you questions in discovery. And you haven't been able to produce that email to me, have you?
Well, you guys were asking if we have an email in our emails.
Mm-hmm.
I was reporting on other news reports about an alert they put out to their group.
All right. Could you find those reports if you needed to? Could you identify your source?
Well, I mean, A, you can hold back a source if you want to, but I remember being online. I can try to go find that again.
What do you mean you can hold back a source if you want to? What does that mean?
I mean, if I have a confidential source on something, I'm allowed to hold back the confidential source for their protection, but that's not what's happened in this case. I remember the news articles about it that we reported on.
So you could find those, right?
I should be able to.
Okay. What do your staff use to send messages to each other in terms of internal applications? Do they use Slack?
I don't know. I've heard that name.
Wait, hold on, let's back up here. When you say you don't know if they use Slack, when you had to answer this question about what methods of communication were used by members of your staff among each other and with sources, what exactly did you do to find that out?
I mean, the only communications with Sandy Hook are like email and verbal and some guests on the show.
That's not what I asked you, Mr. Jones. What did you do to find out what methods of communication your staff used?
I talked to the staff, and I had the lawyer ask the staff to handle it.
What members of staff did you talk to?
I talked to like Rob Dew, and I talked to Zimmerman.
All right, let's talk about Rob Dew first.
Mhm.
You asked Rob Dew, hey, how do InfoWars employees communicate with each other? What did he say?
Objection form.
It was just like, hey, give them all the Sandy Hook stuff.
That's what you said to Rob Dew?
Yeah, just like any type of communications on this, just give it to the lawyer.
How did that help you answer this question? This question is, what methods of communication were used? How did you answer that question?
I asked. I know the modes of communication, like they talk through email, in person, and over the phone, stuff like that.
You just told me you don't know if they use Slack or not, right?
Well, when you said the word Slack, I've heard of that before.
Okay, why is that not in your interrogatory response?
Because I've never thought of that, and I don't even know they use that. I've heard of a bunch of other names too.
Let's just make sure we have this really clear. When that question asked you to identify all methods of communication, including any applications, messaging programs, etc., you didn't make any steps to find out if there were messaging programs. You didn't do that.
I've not seen anybody. I've not used Slack. I've not seen anybody use it.
Again, that's not what I'm asking you. I'm asking you for the purposes of answering these questions. You didn't do anything.
Objection form.
I did say provide anything about Sandy Hook.
I mean, the truth is, you didn't have any problem with what he was doing at Sandy Hook. He said he did a good job.
Well, I had only seen this report. Like as you see in the report, I didn't even know he was up there doing that. I'm like, wow, what's this? Because I saw a thing with his brother, his uncle, that was good. The other stuff I saw, I guess later, didn't like. I'm trying to put it together watching all this.
Well, you didn't fire him for it. You kept him around for another year, didn't you?
No, he wasn't. I don't think he was being paid then. No.
Well, the truth of the matter is, you didn't have a problem with Sandy Hook. You had a problem with him embarrassing you at a Trump rally.
One thing you're right about is I do need to, I guess, spend time and burrow into this more. It's because it's like, I remember a lot of it. I remember what happened, and I think if I go dig even deeper, I can get the specifics. But I remember telling them try to find out the specifics.
This is your second deposition in a Sandy Hook case. You've got more going up in Connecticut. You've had discovery in Connecticut. You've had discovery 3 times in Texas. And you're telling me you think you need to go burrow in and figure out what happened?
Well, no, now that I get these kind of questions, I don't think you were asking me these exact questions last time.
I was very much asking you about Mr. Badondian when he was terminated in the last deposition, wasn't I, Mr. Jones?
I don't remember this video. Did you show me this last time?
I did not show you this video. That's not what I asked, is it? I asked you.
Well,
I
went and I guess tried to get invoices or something, I guess you're saying.
Actually, Mr. Jones, your document production in this case shows you did that in May 2018, right after you were sued. The truth of the matter, Mr. Jones, is you knew immediately after being sued that Dan Badondi was going to be a liability for you, didn't you?
No.
If you had daily show logs that mention that Sandy Hook was discussed on the show, you should be able to produce those videos, correct?
It depends. A lot of the live show was only archived on YouTube. And so then that was taken down.
Okay. When you talk about the videos that were lost, that you don't have, because the YouTube channel was taken down, and the only place you had them saved was natively on YouTube, you don't have those videos. And so by extension, I don't have those videos, correct?
No, those videos were duplicated on other people's channels. I've seen what you guys have. You have basically everything we ever talked about that.
Am I asking you if we have basically everything, or am I asking you if we have everything?
I don't know if you have everything.
Okay. You don't know if I have everything,
I
correct?
don't. No.
Okay. You don't use the teleprompter on your show,
No.
okay? And in all these videos, you just rattle them off, right? You say, porta potties, Bloomberg email, green screen, helicopters in the woods, school was closed, videos showing it was falling and rotting apart, SWAT team. You just rattle them off without a teleprompter.
I remember a video of the rotting school. I remember the helicopter video. I remember the chemical attack in Syria being staged. That's now public.
And you were able to do that without a teleprompter. But today, sitting in deposition, ever since you got sued, all of a sudden you can't remember anything, right?
No, I remember seeing I remember like the photos and video of the rotting school and the mold and the stains all the floor and all that stuff. I just can't. But if it's specifically in a deposition, then you'll say, well, where is that? And then trying to actually pull that very thing up in my head right here. I mean, I don't have photographic memory of the exact thing.
Yeah, I've been asking for a year, haven't I? Still don't have it, do I? Correct?
I just want to be able to answer all this just exactly right, and that's why I can't answer a lot of it because I don't want to. I mean, I want to be accurate as much as possible.
Okay. So for November, during his deposition, I dealt with that for about 3 hours. We didn't get anywhere with Mr. Jones. Same thing with his corporate representatives, as you saw. The entire thing was a mess. They, despite everything that happened, were still not cooperating in discovery in any meaningful way. We had a hearing on that motion, and their counsel at that time said the following, after the hearing did not go too well. He said, I will represent to this court that, regardless if this goes on appeal, that doesn't preclude me from, it stays the court as far as filing motions, etc. It certainly doesn't preclude me from providing additional videos, documents, and information they're seeking during that period of time. And I fully intend to do so. I've already started that process. So again, they're asking now for basically an instruction that, and then he's cut off. Judge Jenkins asks, so what you're saying is you're going to continue to comply with the order. That includes written discovery, which is the exhibit to my order, ordering you to produce those things? Mr. Jeffrey said, absolutely, Judge. I'm representing to the court that I have spent countless hours understanding infrastructure, what exists, et cetera, and I am certainly going to comply with that 100%, stay or no stay, moving forward, absolutely. The court replies, so your point is let it come back to the trial judge who's going to try the case and see just how quickly you do that. Exactly. And how compliant you are with the order before we make potentially outcome determinative decisions. Mr. Jeffrey says, exactly right. On December 20th, Judge Jenkins granted the motion for sanctions and assessed $100,000 in attorney's fees for all the work that we had done in deposition, bringing the motion, etc. The order holds the default judgment under advisement. And I think as you'll see from that order and from the transcript, Judge Jenkins' opinion was that he only needed to decide the things that were immediately important then, which was the TCPA motion and whatever fees we needed. But whatever remedies needed to flow from whatever actions happened here in this court, that needed to be saved for the trial judge who was going to have more control over the trial because he knew he was retiring. I think also another cardinal sort of principle of Judge Jenkins' judicial philosophy is that if it is possible to decide less, it is necessary to decide less. And in that case, he did not want to decide something that he thought you should be deciding, which is here we're going to give him another chance. The guy made a promise. He made a representation to the court to try to avoid a bigger sanction by saying we're going to get this taken care of. We're going to make sure that this happens and that we don't, years don't go by and all this information is lost and we can't ever figure it out again. The court's order says defendants represented at the December 18 hearing that they would continue to supplement discovery to belatedly comply with the October 18 order. The amount of supplemental discovery is a factor that will be considered if the motion for sanctions is reconsidered on remand. That's Exhibit 1 is that order. Now, for the next year and a half, we go on the appeals, and the defendant did not supplement any discovery. They just completely disregarded their promise to Judge Jenkins. They got out from under fire by using that promise, and then they ignored it. They then continued an appeal where obviously the Court of Appeals is very frustrated with them in the Lewis appeal and noted that in that record. And then in the second one, in the Heslin appeal, they went ahead and sanctioned them. So now we have another fine against them from the Court of Appeals because they're still engaging in frivolous litigation. I need to mention right now, too, before we get kind of caught up to date about InfoWars sham defense, because this becomes very important later after they start producing documents. This is in our supplemental brief on page 37. Essentially, InfoWars defended the IED case in Mr. Heslin's case the same way they did Mrs. Lewis's case, which is to say they argued that because Mr. Heslin was not identified in any of the videos claiming IED, as opposed to his defamation claim, that he could not pursue those IED claims. Obviously, we thought this law was bunk, but there's something more important going on. Is in Mr. Heslin's case, we requested from them transcripts of all these videos, and they wouldn't provide them. They said, we don't have them. They didn't give us any transcripts of these videos. In fact, it came to be that there was never any transcripts of a certain amount of these videos because some of them had come off of YouTube and nobody had any transcripts. In the appeal, it's even talked about how there are no transcripts. InfoWars argued because we could not prove, we had no transcript to prove anything of. And they also told the court in multiple representations in these certain videos that they enumerated, we never identified Mr. Heslin. Well, it turns out close to the end of the appeal, we discovered buried in the 5,000-page record of the Lewis case that attached to an unrelated motion was a partial transcript of one of those videos. And that video, although Mr. Heslin's name was misspelled, so we didn't catch it when we searched, they identify Mr. Heslin in that video. In other words, the entire appeal that InfoWars launched against Mr. Heslin on his IED case was based on a false representation by InfoWars that they didn't identify him when they knew that they did. Now, InfoWars claims that it's all my fault, that I should have found this errant transcript in the giant Lewis record before this happened. And maybe we should have found it earlier, and that's certainly true. That doesn't excuse them lying about the fact that they didn't identify him to multiple courts. So all of that was a waste of time. But that actually becomes way more important later, and we'll talk about that in a minute. Let's talk now about coming back on remand. After their appeals failed, they were remanded and a mandate was issued on June 4th. And so let's talk about what they're out of compliance of at that moment.
June 4th, 2021.
Correct, Your Honor, of this year, right? So this is just a few months ago. And they came back and they are out of compliance first with the Heslin IED discovery order with a default under advisement. That's everything we just talked about, where they had responded, but the responses were absolutely bunk and their depositions were a complete joke. The next thing they're out of compliance with is the Heslin defamation discovery order, the one from 2018, which they had already been held in contempt for, and they had never answered in any way, shape, or form. They were also out of compliance with the Lewis IED order, for which they had already paid attorney's fees and admitted that the discovery situation there was a mess. They were also out of compliance with the Posner defamation discovery request. Here's the next case that we haven't even talked about yet, because Posner went up on appeal without any discovery first. We went ahead and just took that one up on appeal because the case was so strong. We didn't feel like we needed any discovery to have any, they didn't have any of these complaints like they've had in their later cases. But they've had discovery served at the outset of those cases. And after the TCPA motion was denied, ever since then, they've just completely ignored them. So that's everything that was pending on remand. And what I thought was going to happen, Your Honor, because I knew when they made that promise, they weren't going to supplement anything during the appeal. I knew that that was a lie. But what I thought might happen is when we got back on remand, I thought the moment that the Texas Supreme Court dismisses their case, they would realize, okay, now we have to do something. And at remand, they would get in a panic and they produced a bunch of things and try to show that they were in compliance with discovery, and that I would have to be arguing to you that that wasn't good enough. That 2 years later, trying to make sense of any of this all would just be a mess. And that's what I was going to have to do. That is not what happened. Nothing could be further from what happened. From June 4th to August 26, 2021, defendants did absolutely nothing in terms of any kind of discovery. There's nothing been produced. And it wasn't until a couple days before this hearing that I was inundated with some documents. And so let's talk about what's happened during this entire summer that InfoWars has thrown in the trash. First, there was June, and for that entire month, there was no efforts made to comply with discovery in any case. And this was just like in 2019 when Mr. Heslin's case came back from remand, and for an entire month, they had done nothing, and Judge Jenkins held them in contempt for that. Well, at the end of the month, with them doing nothing, we went ahead and filed our supplemental brief in support of the default sanctions in Mr. Heslin's IED case. We moved to July, and in July, still nothing's happening. On July 6th, we bring the Heslin and Lewis motions for contempt. We had reached out to them, and that's an exhibit you'll see is our July 2nd letter. It's their only exhibit to their response. And that letter fully explains to them everything that's going on and why aren't you responding? And they, at that point, basically say, we have no idea what you're talking about. Please send us any discovery you say hasn't been responded to. So at that point, it's clear that they haven't even been working on Heslin and Lewis and the motions for contempt. So we file those motions. We also at that point send them the Posner discovery request too and say these haven't been responded to. On July 9th, 3 days later, an oral hearing, we all met together. And at that time, I went through kind of a mini version of what I'm presenting to you now. And we also reminded them of their discovery problems in all three of those cases. One of the things you'll remember I specifically reminded them of on the record is because the defendants in Fontaine had just filed a motion to withdraw their deemed admissions, I told you that I expected for this hearing, when we were scheduling this hearing, that I expected one of the things we'd have to accommodate was a motion to withdraw deemed admissions in the Posner case, because those hadn't been answered. So I was expecting that to happen in a matter of days after the July 9th hearing, because if I heard that, I'd get those denied and served up with a response. Nothing happened. We gave them a deadline until July 16th, I believe, to respond, and they didn't. But we went ahead and gave them some more time just to see if they would. They didn't. So on July 27th, we filed the Posner motion for sanctions, which goes ahead and describes all of this. They continued to do nothing. August opens, and there's a couple developments that happened in Lafferty in August that I need to talk to you about. We filed a supplemental brief about this on August 10th. So on August 6th, that Friday, there were two orders entered. First was a sanction order for continuing failure to comply with discovery. They're in the same place we are. They've been remanded. Now they're trying to go back and figure out and try to see if any of this discovery is getting answered. They have discovery orders there that they're not being complied with. The second order was that they disclosed confidential information from a plaintiff's deposition. This, Your Honor, this was astonishing. They had started a plaintiff's deposition, which at the beginning of the record was designated as attorney's eyes only confidential. Then during the actual deposition, defendant's counsel, the local counsel, Mr. Randonza has working up there in Connecticut, wrote down the things that plaintiff was saying in the deposition, put them in a motion and filed them publicly during the deposition itself. Didn't even wait for a transcript and filed that publicly and disclosed that information. Now, you'll see from the court's orders on this, what's clearly about to happen in Lafferty, which is that now that Lafferty, just like in this case, had already threatened a default sanction if any of this keeps up, that's clearly what's happening now, because the court's orders there takes very extreme language that you can see what's doing, is saying that the plaintiff is now prejudiced from further prosecuting their claim, and that the plaintiff is also prejudiced from taking additional depositions. And the court also says that witnesses are going to be rightly afraid to appear in this case or give forthright testimony, believing that their confidential information will be disclosed. So all of those things about how the plaintiff can't even prosecute their case anymore, it's pretty obvious what's going to happen in Lafferty. I had thought that would actually be taken care of by the time of this hearing, but their August 24th hearing was actually just a status conference call. They have a hearing set for September 24th. There is actually another sanctions pending motion regarding some analytics information that was produced that is also extremely troubling. So it's pretty clear where we're heading in Lafferty. They're heading for the same place. Now we get into the second week of August, defendants still haven't done anything. And at this point, we get this very strange email where you'll see in hearing exhibit 5, is that Mr. Reeves stated that his client does not possess what production has been provided to date. He asked plaintiffs to send me the production you have indeed received to date. So I'm not sure how you would even supplement your own discovery if you don't even know what you've produced. But at this point, now this, as you may remember, this is 6 days before the originally scheduled hearing of this matter. They were asking me to send them the production because they don't even have it. A week later, we still don't have anything. And their counsel wrote again asking if I would agree to a protective order for the overdue documents. Counsel said the documents were ready to produce, but were being withheld because defendants require such an order to be entered. And we told them very straight up, you cannot seek protection over discovery that is already due. Rule 192 requires you to make that motion or seek protection within the time period for the responses. And when 3-year-old discovery that you are already under contempt for not producing, you cannot have a protective order. The next week, we still don't have documents. We get 2 emails that day. The first one very early in the morning. Counsel wrote to us asking for consent for a motion for consolidated discovery plan. We had no interest in that. We told them, the court asked us to do a discovery plan. We just did it. We're now days before the hearing. We'll talk to you next week after the hearing if you want to talk about this, but we have no interest in doing a discovery plan right now. He said he was finalizing document production, which will only be produced in the Lewis matter due to the confidentiality of certain documents. But counsel stated you will have these documents today. We did not get those documents.
I'm sorry, Mr. Bankston, which of the binders has these exhibits?
Oh, I'm sorry, Your Honor. So these exhibits that I'm talking about right now, hearing exhibits, were uploaded to the box last night after defendants filed their responses. So they're in
Oh, so they're not in one of the binders you gave me?
no, unfortunately not. These are in response to the responses.
Okay, that's fine then. I just thought I would flip through as you were talking. That's okay.
Sure. But yeah, they are in there noted as plaintiff's hearing exhibits. So
Okay.
so then later that day or that evening, we didn't get the documents. Counsel wrote us that night and said he will be moving for a protective order in Heslin and Posner, and that defendants intended to withhold confidential documents, and no documents were produced that day. Then on August 26th, just a couple days ago at 6 p.m., counsel provided about 6,000 pages of supplemental production, and as promised, withheld confidential documents from both Heslin and Posner cases, despite the fact that he has no ability to object to those cases and he's under contempt in the Heslin case. Let's talk about what was produced in that 6,000 pages, because this is where it really starts to get interesting. The first thing that was produced was nearly 2,500 pages of transcripts of InfoWars videos. And there's a lot of reasons why this is very alarming. First of all, it might be excusable, say, if there were 2,500 pages of transcripts buried somewhere in Mr. Jones's corporate files that were difficult to locate, and they're just now finding them now, something like that. The problem, Your Honor, is that these transcripts were prepared by a court reporter. These were made, a great proportion of these transcripts were made in June and July of 2019. They had them commissioned to be made by a court reporter. That was months before they had told me in the Heslin case, there were no transcripts, and they didn't produce any of these transcripts, but they had them the whole time prepared by a court reporter. And what's shocking about that, of course, is that much later in that case, they then attempted to argue to me that they didn't identify Mr. Heslin and that my case was deficient because I didn't have transcripts. And the entire time they had actually prepared them with a court reporter. The other thing that's very disturbing about these transcripts is there are more transcripts than there are videos that I have been produced. And right here on the screen, you'll see a list of dates. They're all titled differently. Some of them have episode titles, some of them just have dates. All of these dates are dates I don't have videos for. And these are videos that mention Sandy Hook. And they're videos that they obviously provided to a court reporter to transcribe, but they never provided to me. This isn't tip of the iceberg too, because I know about a ton of videos that aren't on this list, but it is extremely disturbing to me that these transcripts exist and these videos existed. They were never produced to me and in fact hidden and used to try to get Mr. Heslin's case dismissed. The next thing that they produced, as the bulk of what they produced, is 2,100 pages of Google Analytics screenshots and Excel spreadsheets. What this is a bunch of data about entry links, keywords, search terms, and exit pages for the Infowars.com website. This is not responsive to anything in our discovery requests that are issued in this motion. None of the discovery that occurred prior to remand has anything to do with this. There is one request we issued after remand that's not related to this motion that was produce your analytics or web traffic for every video identified in plaintiff's petition. And some of the videos in plaintiff's petition have promotional pages on the InfoWars website here. But ultimately, this is kind of not really responsive to anything. I mean, there's buried in here is some responsive information, I guess, to that, but not fully responsive. But mostly, this has nothing to do with what we're talking about today. We may end up having to talk about it later. The next thing they gave us, there's this gentleman, well, not a gentleman.
So,
he's
Mr. Bankston, are you trying to say that they just included that to clog your review?
I don't want to make that representation, Your Honor. I certainly hope that's not why. I mean, I'm hoping that they thought it was partially responsive to a post remand request. I'm going to be charitable and say that that's what I think. Then again, Your Honor, you are right that there is thousands of pages of things that are not responsive to me there. I don't need to know exit pages for InfoWars, things like that. I mean, it is very non-responsive. The next thing they produced to me, there's a man named Wolfgang Halbig. He's a conspiracy theorist crank who has pursued these families for years, saying that Sandy Hook is fake. He's been a guest on InfoWars several times. They produced me about 600 pages of strange emails and a transcript of a town meeting he was at, which is responsive. That's fine. I'm just saying it didn't have anything to do with what we were asking for in this motion. They gave us 239 pages of InfoWars articles, some high quality scans, some from litigation. All of them were previously produced. And then there were a few other things they produced. About 150 pages of messages to the news tip email address. We already have thousands of those. I haven't been able to check yet, but I'm pretty sure most of those are going to be duplicates. There are a few dozen pages from another conspiracy theorist blog named Jim Fetzer, who they've cited on occasion, a handful of emails. There's a few dozen internal emails regarding show scheduling and topics. There's around a dozen press inquiries to InfoWars about this lawsuit. For some reason, there's affidavits from Jones and Dew in March 2019 regarding Lafferty requests. And there's David Jones' deposition transcript, which we don't understand why that's in there either. That was an exhibit to our sanctions motion, in fact. There were some interesting things in there, Your Honor. This is an email actually that was produced in 2019 before remand. And this is what you're looking at is an email notification sent to Rob Dew that he got a message on Twitter, a private message. And this message is 3 days before they defamed Mr. Heslin. And it's talking about Mr. Heslin's, the interview he had with Megyn Kelly. And we obviously can't see the full message because we don't have access to that. But in 2021, they produced this email, which is another notification. And this is a month later. And this one is on the day of the second video that defamed Mr. Heslin. And as you can see from this message, this person is engaging in a conversation with Rob, with Mr. Dew, who is obviously responding and giving his thoughts. And they're talking more about these relevant events. So here is, we know that there are messages from Mr. Dew on Twitter giving their mental state of mind at the exact moment that they defamed Mr. Heslin. We don't have them because this is social media evidence. We only have these notifications to know that they exist. We got a couple of other surprises. First, we got an email from Chief Editor Paul Watson discussing the messaging application Basecamp. And we've never heard of this messaging application in this case. This is one of the things they were supposed to identify. And we don't know that anybody has ever accounted for this or searched this or knows anything about it. We also got an email from Roger Stone to Alex Jones referencing Sandy Hook. And we had been told that Alex Jones doesn't use email to communicate with people. We had been told that there were no Sandy Hook conversations. But now all of a sudden there's this single email from Roger Stone about Sandy Hook. I mean, we think that's because they think that we'll eventually get that email from Roger Stone. We don't know why we're just now getting one solitary email from Alex Jones. But most importantly, let's talk about what we don't have. Discovery responses. So first, the very first one I talked to you about, Mr. Heslin's case, we don't have discovery responses on his defamation claim, 32 pages of written discovery. None of that has ever been answered. And defendants apparently seem to think they have answered it, which is strange to me, but they have not answered that. They haven't answered any discovery in Posner. And then the discovery responses that you have from Mr. Heslin's IAD claim and Mrs. Lewis's claim have both been admitted that they're patently insufficient, but there's never been any supplemental discovery responses. We still don't have the most basic information about this case. We don't even like requests for disclosures, which are already due. We don't have. We don't know who has knowledge of relevant facts, what the videos are, who's involved, any of it. Documents have never been supplemented in any meaningful way. We're going to talk a really important one about this is the amount of emails they should have, and we'll talk about that in just a minute. Depositions. We were owed 4 different depositions in Mr. Heslin's case that we have never gotten. And one of those, actually a couple of those are pretty important because, for instance, we were supposed to have a deposition of Owen Schroyer, and we haven't had that in 3 years. And the problem with that is Mr. Schroyer was just arrested on federal indictment for insurrection activities on January 6th. And so we're not sure if we're ever going to have an opportunity to depose him. And in fact, in Mr. Schroyer's arrest affidavit and all the pictures of him breaking the law where he's not supposed to be, Mr. Jones is standing right next to him. So we have a strong suspicion that Mr. Jones is about to face federal indictment as well and arrest. We're not sure we're ever going to get those depositions. The videos have never been supplemented. And as we see now, they have videos that I don't have, and there are videos out there they should have. And if they were to go through their own documents, they would know about tons of more videos, and they have not done any reasonable good faith effort to get us those. And we don't have social media evidence. That's all gone now too. And you've seen that talked about in our brief quite a lot. And who knows what else? This is really the important part, is that when there was a promise made to supplement this discovery, it was because discovery had been so badly bunked for a year, waiting another 2 years wasn't going to do it. I mean, now we're talking about having to go find people 3 years out from where we would have normally done it to see who was involved in this case, who might still have documents, do they still even have them? The quality of the evidence of people's memories and the physical evidence all degrades. And we have now been kept from discovering any of the basic facts about our case for 3 years. We don't know what else is out there. For instance, thank gosh that Robert Jacobson, their video editor at one point, decided to approach us and say he felt bad about what happened and needed to testify. We don't know who else is out there. We don't know what other information exists. Let's talk now, Your Honor, about these responses. And I definitely agree with you that filing these responses last night, or actually, I believe they filed them while you were in trial at this last afternoon and I was in deposition. And then when we got out, we would have had to have been expected to drop everything we were doing and read these last night. And I know you didn't, but I did. I had my wife take care of my kid and spent all night dealing with these. These responses further show defendants' utter conscious disregard for these cases. They're really quite amazing. So I want to talk a little bit about what was said in these responses because you haven't gotten a chance to read them yet. So this will be your first look. First, there is the Posner response I want to talk about, and they just flatly admit that they have not responded to discovery. They do not dispute that at all. They say the undersigned had the misunderstanding that plaintiff's discovery request had already been responded to. They say that when plaintiff's counsel emailed regarding the responses to plaintiff's discovery request, the undersigned failed to recognize that these outstanding discovery requests had not actually been responded to. This is very strange, Your Honor. Because if you look at their sole exhibit to their motion, to their response, is their exhibit 1 is the July 2nd email. And you'll notice at the bottom of the email is my first email on that one. And I lay out to them on every case exactly what's wrong and what they need to do. And in Posner, it's very simple. I told them regarding that case, your clients have not responded to plaintiff's initial discovery requests. Those responses were due on September 1st, 2018. When the appeal was initiated, the responses were almost 2 weeks overdue. Upon remand, you have made no efforts to respond. Now the requests are nearly a month and a half overdue. And now they're 3.5 months overdue.
I'm just gonna, because I can't help it, point out that while I appreciate you taking the time and effort to lay out what they have not responded to yet, that was not your obligation. You filed the discovery and it is their obligation to keep track of whether they have responded or not.
I would agree with you, Your Honor. I definitely agree. But this is an unusual case, and I sometimes have to do the lifting for both sides in order for anything to make sense.
Well, I appreciate it. I just wanted to be clear that that was not in any way your obligation.
Thank you, Your Honor. But again, Your Honor, it's interesting. I'm right with you there. But one thing I wanted to make sure and do was to put this out there as clear as possible so that we could demonstrate their absolute conscious disregard. So, and one place I did that again was the July 9th oral hearing. I reminded them that no responses have been served. I told them they needed to file a motion to undeem the admissions, and they didn't do that. A whole month, then the rest of that month passed, and then July 27th on the motion for sanctions, all of the above was summarized, that they had never responded to the discovery request, that all of this had happened in oral hearing, that I reminded them to file the motion to withdraw the admissions. They didn't do any of it. They just completely ignored it, a complete conscious disregard. August 30th, they filed the defamation response in Mr. Heslin's case. So let's talk about that one really quick. This one is also astonishing, Your Honor. They say the motion fails to provide any pointed explanation as to what alleged discovery abuses by defendants are ongoing, which would warrant a contempt finding beyond making the nebulous, conclusory claims that defendants have failed to adhere to their discovery obligations. Defendants have never responded to the August 30th, 31st discovery order. That is 30 pages of written discovery. That is 4 depositions that they were supposed to give, that they first told the court, you don't have authority to make us do this. Then they launched an appeal with no jurisdiction. Then they came back, refused to respond, and the court held them in contempt and fined them $25,000. Then they appealed again, launched a frivolous appeal for which they were sanctioned, came back, and still have never responded to these discovery requests. And now they have the temerity to tell this court that I'm being vexatious and that there is no way they could possibly know what they would have to do to comply with this order. They've never responded. On Heslin Contempt Exhibit 10, on July 2nd, there's that email that I sent them that we just talked about. And they were reminded that they never responded. In very clear language, I laid out this exact situation, how in 2018, they chose not to respond. In 2019, they again continued not to respond. And how now, where are the responses? Why have they not responded? Defendants now claim that, hey, how would they ever know what to do? It's frankly, Your Honor, the disregard to respond to a second contempt motion in this way, to not even know that you haven't answered the discovery. When I have provided you that, I sent them the discovery. The order has it all set out. And these are in orders of the court. It's frankly just baffling to me, Your Honor. Also, this is conscious disregard. Let's talk about, oh, my screen popped out. There we are. All right. Let's talk about Lewis really quick. That response, they say that the plaintiff characterizes the Lewis production as largely containing non-responsive materials. Plaintiff truly makes no effort to provide evidentiary support for this allegation. If you look at Lewis Contempt Exhibit 5, it is a copy of our April 2nd, 2019 Lewis reply on motion for sanctions. You'll remember that motion was filed when they had produced nothing. And then after the motion was filed on the eve of the hearing, they did this document dump. That reply goes into extreme detail, sets out how the production was deficient and non-responsive, gives example documents. It contains a declaration from our expert who was helping us review it, who describes what an incredible mess it was. So from our standpoint, yes, we absolutely have provided support for that. But more importantly, this is sort of just relitigating things that were already decided in 2019. Because they say, for instance, that the Lewis motion does not show how defendants have failed to comply with such orders and how, when, and by what means defendants have abused the discovery process. But they admitted in that hearing that the Lewis production was inadequate. They agreed to pay attorney's fees. They totally understood what a mess they made of the situation and promised to fix it. And in fact, right after that, their other attorney said that the discovery situation was a mess. And a short time after that, they ended up producing child pornography. We all know that the Lewis production is in no way adequate, but they don't seem to want to supplement their answers in any way. Let's talk about the Heslin IED response now. They say that plaintiff's supplemental brief is nothing more than a failed attempt to have this court reconsider that ruling and implement additional sanctions when that situation has already been addressed. And Your Honor, I think we both know that that is a flat misreading of the court's order and the transcript, where this court definitely was in the mindset that if this discovery was not supplemented as Mr. Jeffries promised, that additional sanctions would be considered. And that he was expressly holding this off to let you decide how to deal with all of this situation. They talk about the document situation. I want to address this really well too, because they say that what plaintiff conveniently omits from his briefing is that the scope of discovery in Lafferty is much wider and all-encompassing than the discovery at issue in this case. For example, plaintiff cites to an affidavit of David Jones filed in the Lafferty matter that search terms in that case yielded approximately 80,000 emails that were potentially responsive to the Lafferty plaintiff's discovery request. But in no way does that support the idea that those emails are responsive to this plaintiff's limited discovery request. Your Honor, if you'll actually look at that affidavit that's in our response, what Mr. Jones said is that searching for the terms Sandy Hook in emails returned 80,000 emails, and that they expected similar volumes for other search terms in the Lafferty plaintiff's request. We've obviously requested all emails with Sandy Hook in them. We have about 11,000 total documents in this case, and I would just give you a rough estimate of about half of them contain the term Sandy Hook in them. So we're not anywhere close to that universe. And most of those emails we have, a good portion of it, Your Honor, is the same 15 people who are writing InfoWars unsolicited, and they are extremely mentally ill and writing 500-page emails to InfoWars on a weekly basis. And it's these same 10 people over and over again. So what we're seeing here is not in any way a search of this. We also took the deposition of Michael Zimmerman, who is like a 23-year-old IT employee at InfoWars who was working on some of this. And he confirmed for us, in this case, David Jones's testimony, that there should be 80,000 emails relating to Sandy Hook. Now, they also talk about messaging systems in their response. They say that free speech system utilized Slack as a messaging system, but that system has not been utilized since April 2016, and that data has been preserved, and to the undersigned's best knowledge has been produced. I don't know what this undersigned's best knowledge is, because he doesn't have knowledge. I mean, this is just he's copying and pasting something from 2019 or something. I don't know. I don't think anybody's ever alleged that Slack data has been preserved or produced. We have testimony on our record showing in our motion showing that Slack data has not been preserved and is not available to the company anymore. If it is available, we have notifications from emails that show that Sandy Hook was discussed in the Slack system. So there should be those messages. Those haven't been produced. The same deal with this Rocket Chat makes the exact same statement. And we don't have any Rocket Chat production, none. And we don't have any indication that that's been preserved. You'll also notice there's a gap between 2016 and 2018. They don't say what messaging system they were using at that point, but we know that that exists too, and none of this has been accounted for. This stuff about the undersigned's best knowledge, you're going to see this a lot in this case. This is because Mr. Reeves is not getting any cooperation from his client. So the undersigned's best knowledge is just a guess on his part at this point.
Your Honor, I would object to that because he doesn't know what I'm talking about. I mean, I can understand that he's frustrated here, but he doesn't need to be opining on what I'm saying. If I can certainly discuss it with you, but I would object to that statement there.
Well, you can object to it, but I can also read and make a conclusion about what that statement means.
I understand, Your Honor. I'm just pointing
And what
out.
it means is you don't know. You don't have any idea. Because if you knew, you would say so. Go ahead, Mr. Bankston.
Okay. The other thing that the IED response from them last night addresses is videos. It says, while plaintiff's briefing addresses a couple of videos he says have not been produced by defendants, plaintiff notably does not provide any information to the court as how such videos are in any way relevant or connected to his IED claims in this case. And Your Honor, this is so ridiculous because if a video is about Sandy Hook, it's obviously relevant. I mean, we are alleging a continuing course of conduct here. The other thing that's ridiculous about this is when you're already under contempt for not producing it, the idea that it's not relevant is not a great argument at this point. This is obviously directly connected to my case. It's also way more than a couple of videos. We identified about 6 in that brief right there. We've given them a list with others they haven't produced, and we know there's ones they haven't given us. No effort has ever been made to answer even the most basic interrogatory about what videos exist. Then there's social media evidence. Their excuse here, you saw in our motion how they had every opportunity in the world to preserve this, and they knew that it was about to be deleted. They got every threat over a course of months. And they said it's our problem, because we haven't given third-party subpoenas to any of the social media companies. And the problem here is during the first period of this case, up until this remand, I was under discovery stays where I could only have the expedited discovery against the defendants that was granted by the court. I couldn't just go out and do discovery. But more importantly, if they have a superior right of access to this, these are their accounts and they can get them much easier from Facebook or Twitter than I can. This would be like if I was saying, well, I have medical records, but I'm not going to try to get them for you. You got to go get them. In this situation, I have no reason whatsoever that Facebook, Twitter, or YouTube is going to comply with me in any way. But they have to make a reasonable effort to get things that are within their custody or control. And they haven't tried to do that at all. The other thing that is said in this response is that the undersigned counsel was not involved in those disputes, but certainly has reviewed the record and understands where the issues were alleged to exist and what has been done to try to remedy those discovery disputes. The undersigned has been personally reviewing over 75,000 documents gathered during this litigation. Your Honor, respectfully, from what you've seen today, this is not true. Mr. Reeves does not understand where the issues were alleged to exist. He believes he's responded to discovery he's never even responded to, which tells you something, Your Honor, which tells you that he has never checked to see and hold in his hands the discovery responses that have been issued in this case. In other words, he is telling you in a contempt motion that there is wild, spurious accusations against them that should never be granted, and they're in compliance because they have responded. And he told you that without ever laying his hands on the discovery responses to see if they were compliant. Because if he had tried, he'd realize there are none. And so to then say he understands what issues are alleged to exist, no, he doesn't. And they have not tried to remedy these discovery disputes. They tried to do some 11th hour fig leaf where they produced 6,000 pages of mostly useless documents. He also says the undersigned's been reviewing all those 75,000 pages. They surely didn't even have those till at least August 11th when they told us they didn't have them and they wanted us to give them to them. I'm not even sure I fully believe right now that they do have them. I think maybe they kind of got embarrassed and said, no, okay, we're okay. Don't give us the documents. See, the idea that since August 11, with the other briefing defendants have done, with the other briefing I know Mr. Reeves has done in another court with me, there's no way since August 11th you've reviewed 75,000 pages of documents. I did that. I remember doing that. I couldn't have done it in that speed of time, even with nothing else going on. There's also a response made about the pattern of conduct in this case. Defendants say that none of the cases cited by plaintiff, the vast majority of which are non-Texas cases, supports the position that the court can consider alleged discovery violations in entirely separate matters. I mean, that's just not true. First of all, look at page 42. There's Karen versus Smaby. And that's where you had conduct, and this is from my home district, where it was in one court of the district in Harris County, but there was also discovery abuse previously in another district court of that county. We'll talk about some other cases like that. In fact, it's a good place to transition right now to talk about the legal principles underneath, underlying.
Take a little break then.
That's great. That's great,
Yeah.
Your Honor.
So let's take like a 15-minute break. We'll come back at 10:30. My assistant will put up a break sign, but if you don't want whatever you're doing on break visible or audible on YouTube, you need to turn your camera and your sound off. Okay?
All right. Thank you, Your Honor.
See you at 10:30.
Okay.
Mr. Bankston, you can pick back up.
All right. I think I only have about maybe something like 10, 15 more minutes with you, hopefully.
All right.
Let me. So we just wrapped up talking about the responses that were filed yesterday. I did also want to add on that to kind of follow back up on your comments about that. Staff attorney Mr. Denton had sent us out a chart of everything for this hearing to get us ready, and had asked us sort of as a convenience, when we were scheduled on August 17th, can you please get me paper copies of all relevant pleadings by the 6th? That following week, defendants had contacted the court and said, hey, we didn't know that necessarily applied to us. We're going to file our response tomorrow on the 10th. And at that time, Mr. Denton said, look, hey, it's just try to be a guideline. There's no court order here setting a deadline, but the judge would like you to get your pleadings in as soon as you can, so she has plenty of time to review them. And that was back on the 10th. And they went ahead and just sat on those until the night before the hearing. And I do feel like that was done in a calculated way so that there would be no time to reply to that. There would be no time to look at that. Luckily, I did have the ability last night to throw everything to the sidelines and dive into those. But we actually believe that their failure to address these motions that have been pending for quite some time and that are quite serious, and the gravity of them, their failure to really respond to those, to us, speaks to the conscious disregard as well.
I agree with you. And I want to make it clear that in all cases in front of me, Mr. Reeves, whether they involve Alex Jones or another party, from now on, when you are the attorney, I'm going to set deadlines for when everything is due. And particularly in these cases. And if they're late, I'm not going to consider them.
I understand. And there was no gamesmanship, Your Honor. There was simply
Hard to believe.
refiles and stuff, but
It's
well,
hard
okay.
to believe.
I understand that, Your Honor, but I can tell you for me personally, there was no gamesmanship for me. But I understand what you're going to do, and I can appreciate that, and I'll make sure that we meet whatever deadlines the court sets.
Which I shouldn't have to do. And I don't. And almost any case. All right,
Let's move on to legal principles underlying this motion. And as you know, it's interesting because they're all essentially motions under 215. All right, we're talking about discovery abuse and the powers available to you when a party is engaged in this kind of years of discovery abuse. The first principle that we talked about, first principle we talked about in our motion on page 40 is that persistent discovery abuse justifies a presumption that a defense lacks merit. And when the court can reach a presumption that the defense lacks merit, default sanctions can be granted. The court in doing so must only consider and not test lesser sanctions. Obviously, in these cases, the court has tested all sorts of sanctions. It's interesting, though, that InfoWars' argument is essentially going to be because we have only been sanctioned once in each case, or because there's only been discovery violations once each case, you can't consider what happened in the past. You just got to keep on giving us the lower sanction each and every time, but we do something in your court. This isn't the law, though, because as we point out on page 41, the trial court may consider action taken in another court when that action is relevant to the case pending before the trial court. And in here, it's not even really another court really so much, because so much of this already happened in your court. Defendants want to say in their response that this sort of law only applies when the same lawsuit has been transferred between courts, but you can't consider anything else. And that's just flatly not true. Not only have we talked about the case Cambry earlier, but I actually think Zenergy is maybe the most important case for you to look at in this dispute. We put that into the box and highlighted it for you. In Zenergy is so factually similar here, but far less egregious. Zenergy was a corporate dispute where both parties sued each other. And in that case, the defendants did not provide discovery. And it wasn't nearly as far ranging as ours, but there was certain information the defendants did not provide. They had also moved for summary judgment at the same time, which is dispositive in much the same way a TCPA motion is. It was discovered that they had hid discovery, didn't fully comply. So there was a sanctions hearing held. And then at that sanctions hearing, the court didn't take action, much like in this case. The court said, well, there's going to be a stay of proceedings for a little while in this case. So we're going to hold off on making a ruling now. The stay went for a year. And then upon a year, when they came back from the stay, the judge noted, well, Zenergy hasn't done anything to respond to these requests, even though they've known for a year that default sanctions could be imminent, and they haven't done anything to get that information in front of the court. There had never been any prior discovery abuse in Zenergy. But what happened is that the judge in that case noted that two of the three same defendants had committed discovery abuse in a previous case. It's unclear from Zenergy whether that was even a state case. That might have been a federal case. But it was a previous similar lawsuit involving Zenergy in which they had been sanctioned for similar discovery abuse. The judge in that case said, well, considering this prior conduct, I can assume that my sanctions here are not going to be effective. So that's why a default was granted. Under review by the Corpus Christi court, they said he was entirely proper to do that because he could rely on the fact that they had been sanctioned by the same conduct before. Then if they had repeated it in front of this next judge, that judge should not have any confidence that his sanctions are going to change their behavior. So in Zenergy, under much less worse facts, default was granted. There's also, we need to talk a little bit about the defendant's bad faith. Defendants are correct that simply bad faith or things you do outside of the litigation are not an independent basis for sanctions under 215. But once the court determines that 215 sanctions are appropriate and it starts to consider what kind of sanctions would be effective, it is absolutely allowed to consider defendants' bad faith approach to the litigation in general. And one of those first things you can talk about is, I know the video that we played earlier didn't really have volume to it, so I may need to play that at the very end of this presentation again. But you would see from that video, Jones has created a hostile atmosphere, and it will discourage people from participating in the litigation. He has shown an abject disrespect for these proceedings and the safety of everybody involved. As you may know from the briefing, right after that video, the judge in Connecticut started getting death threats that the FBI warned her about. The plaintiffs' counsel did up there. They actually got police to guard their office. My wife got a message on her phone after Mr. Jones called me a gremlin and a goblin who was terrorizing InfoWars audience, and he asked them to stand up. He does this. He has no problem creating that atmosphere. He also is obsessed with this idea that there is a conspiracy that has made these trials show trials, and that there are powerful forces in the Democratic Party headed by Hillary Clinton, who apparently control us, who are causing him to become railroaded. He has called Judge Jenkins a hoodwinked mainline liberal who is being manipulated. He has openly called these lawsuits show trials. And there's a really good understanding when you see his conduct of that nature, why he's not participating in discovery and why these sanctions are not effective. The defendant's conduct was egregious. And what I want to really emphasize is how the courts frequently default parties for so much less than this. If we look, for instance, at Alma Investments, this was a lawsuit about some condo developments in South Padre Island, a multi-million-dollar lawsuits where the companies were suing each other. In that case, there were 2 failures to appear at deposition and a failure to deposit funds in the registry. They said the court twice ordered the Packadays to appear for depositions, but both orders were not followed. Additionally, the trial court ordered Alma, the company, to deposit $20,000 in the registry of the court to pay an auditor. That's all that happened, and those parties lost their ability to defend their claim. Right. And I think you would have to look at that situation and think about the Packadays and think if they were to think that they were denied the ability to put on their case, but Mr. Jones and what he did is going to put on his case. And I think you would have to understand that the Packadays would think that was very unfair. The same thing would be true in Solomon versus Lassay. There were just 3 failures to appear at deposition, and one of them occurred after a monetary sanction of $1,000. Which is far less egregious than what's happened here, with numerous depositions missed, numerous monetary sanctions, numerous cases where they are not responding to discovery, and where they're across the board obstructing every other discovery. Here, again, you would look at somebody like Michelle Solomon, and what would he think it to know that he was kicked out of his case, but Mr. Jones is going to keep going in his? I think that would be the reaction basically across the state, is that if people were to see what has happened here, and then see Mr. Jones continue, the reaction would be, Alex Jones got away with what? And that has really been the jaw-dropping reaction of everybody who's seen this case. The other thing I want to remind the court is that discovery affects all aspects of these cases. And I've put down here the 3 elements that we're going to have to prove, for instance, in our defamation cases. And the reason is because one of the things the court might be inclined to do in a situation like this is to pursue a lesser sanction of saying, I'm going to make an evidentiary finding on a certain issue in the case that discovery affected, something less than a default. Well, here I want to go over these elements, right? And how every single one of them has been blocked by discovery. First, there is published. And we know that there's a dispute over who published what. As you remember from our last hearings, whether InfoWars LLC was involved in the discovery there, and we've been just absolutely obstructed discovery on InfoWars LLC. We have to prove it's a false statement. And obviously, whether the statements are false can be proven with discovery from the defendant, because there's a good chance that they're going to give us discovery that they knew it was false. We also need to prove it was a statement of fact and not an opinion. But if defendants are relying on the idea that they were simply analyzing certain disclosed facts and giving their opinion based on those disclosed facts, if we discover evidence that they knew that those facts were false, then they are not entitled to express that opinion, and they do not get that defense. Furthermore, prior statements of the defendant may in fact change the meaning of the actual statements in the challenge statements. So for a lot of reasons, discovery is important to opinion defenses. Then we also have whether it's about the plaintiff. Imagine with me that InfoWars has a document saying, ha ha ha, this new broadcast we're going to do is really going to mess over Lenny Posner's life. It would be very difficult for them to come back and then say nobody could possibly interpret that video as being about Lenny Posner. That impeachment evidence could be critical. The idea that the statement caused the plaintiff reputational harm is my next element. And honestly, that one's not really important here because these are per se cases. So there's the presumption that the plaintiff's caused harm. But even still, there's clearly, we could get evidence of reputational harm from the defendant's discovery. And finally, that defendants acted with the required fault. And this one here is pretty obvious to me too, because everything under the sun that they could produce to us could possibly go to their fault. And so if all of those are the issues, if any of those are left intact, we are actually still suffering prejudice from this discovery and the fact that it has been absolutely botched and will never be fixed. The last thing that defendant's counsel leaves you with is his plea. All right, he says to you this plea that the undersigned requests that the court grant him an opportunity to prove that he has control of this discovery situation. Well, with respect, he has already had that opportunity, and he has thoroughly proven that he does not have control of this discovery situation. Doesn't even understand the discovery situation, much less have control over it. But what's really interesting to me is that this is the exact same plea given to this court to avoid default sanctions in 2019. This is exactly the same thing that Mr. Jeffries said to this court, and how much time he had put into getting an understanding of what's going on, and they were going to get this fixed. The exact same excuse. And what's even more ironic is that was also the same excuse used by the lawyer before him, and the lawyer before him, and the lawyer before him. It just keeps going, Your Honor. It's like that movie Groundhog Day with Bill Murray. And I remember him saying this line in it of, one day I went to Mexico and had a great vacation down there. I spent all day on the beach, drank pina coladas. Why couldn't I have that day over and over and over again? And we really have been stuck in the same situation. So to hear this defense counsel make this exact same plea after having just completely trashed the entire summer. Remember that defendant's counsel came to this court and negotiated and agreed for a discovery plan that has me designating experts in about 14 days. And I don't have any discovery to do that with. Now, that's not going to stop me. I'm still going to designate my experts because we've realized we've gotten all the discovery we're ever going to get. There's never, ever going to be a fix to this problem. There is a reason. You might wonder, and it kind of starts to make sense, why every single counsel comes to you and makes the same plea, and why no counsel can ever get control of the discovery situation. It's because of this man. And we've told you this in our brief. We've set this very clearly. There's a reason why no sanctions have ever been effective at changing this man's behavior. He will continue to introduce chaos, defiance, and danger into this lawsuit because it is built straight into his DNA. We have had all of these different lawyers, and it has been the one thing that has remained consistent is Mr. Jones' complete disregard for these proceedings, and in fact, his open attacks on these proceedings. And it's really for that reason, Your Honor, is that we now have given you proposed orders on all the cases. And the discovery abuse has gotten so bad these last 3 months, the conscious disregard so shocking that we are asking for a default judgment in all 4 cases. Because in every single case, you have a long history of discovery abuse you can rely on to show you that anything you try to do right now to compel compliance is not going to work. Your Honor, so that is what we are requesting. We have added proposed orders to the box. There is one other thing I'd like to do. I've been let known that during the playing of this first video that we're looking at a screenshot right now, Your Honor, that the sound wasn't working, so wasn't able to be heard. It's a 2-minute video, and I do think it's important for the court to hear what is heard. So if it's okay with you, I'd like to close by playing that 2-minute video.
All right. I heard most of it, but that's okay. You can play it again.
Okay. Yeah, just figure for. All right, Your Honor. As closing, let me just say, the person you saw there at the end of that video was Norman Pattis. He's a local counsel for Mr. Jones in Connecticut. And the pattern that you see in this case, and I see it over and over and over, is that they select some local counsel who comes in and takes these falls on the sword. And it's always a new local counsel that they throw under the bus every single time. And really what the elephant in the room is the elephant that's not in the room right now, which is Mr. Randonza. And that he has now told you in his briefing that he's really actually been InfoWars corporate counsel and coordinating the litigation from all over. And that seems to be accurate. And you have a party who's non-appearing, a person who's non-appearing attorney who's acting as corporate counsel, just general counsel. He is essentially the party. He is their corporate lawyer. And you have these attorneys who come in who are put in these awkward positions. Like you can see, Mr. Pattis really found himself in an awkward position there. And each of these attorneys will then come in the next local counsel will blame it on the local counsel before. And so here we have Mr. Reeves again, who's the latest series in that. And I'm expecting just like Mr. Jeffries did, he'll blame the one before him. But what you see is the consistent behavior of the party itself. And that is a reason why we think anything more at this point just becomes ridiculous. So what we're asking is the default judgment and to let a trial proceed forward just on whether Jones's conduct merits punitive damages, what the compensatory damages are, and if there is a punitive damages fine, what the punitive damages should be. And that's what we'd ask you for today, Your Honor.
So I printed out your proposed orders. I haven't read them yet. because I didn't know they were there until this morning. My concern is you need this discovery even for a damages trial.
I
So are
think
you asking me to default liability and order the discovery still be responded to again?
it's interesting. I do think you're right that there will be need to be some damages discovery from their end that's directed towards them. I don't honestly think it's ever I'm going to get much. And I don't. Let me put it this way: I don't think the discovery that was issued under the court's prior discovery orders, which was TCPA directed discovery, all that goes to my burdens. So I don't think we've served any discovery yet that would be subject to these orders that would be damage related. Certainly, if we go forward and there's something going on with damages that we need to bring to the court, before we could have that. But I'm just kind of hoping that we can go forward and at least put on a damages trial, even if they don't produce us anything.
Right. I mean, you can, but my question is just, if you're trying to get punitive damages, you probably do need more discovery.
I think that's true. I think, well, I'm going to tell you, Your Honor, I think I have enough to prove punitive damages right now. I do.
Okay. You might want more.
I
Let's put it
do.
that way.
Exactly. Correct, Your Honor.
Okay. But your position is you'll file that later.
Right. If we need to, if for instance, after this hearing and I have more of an understanding of what the scope of discovery is like going forward, then we'll serve new discovery requests and depositions that we may need. I think that'll be very limited.
Okay. All right. Thank you. Mr. Reeves.
Okay, thank you, Your Honor. Mr. Bankston he kind of merged everything together, and I feel like, for at least my purposes, the best way to approach this is individually with each motion, so that we can make sure that we have, a clear understanding of each particular motion and what is requested here. The first thing I want to say is that, the statement at the very end where it pulled out, where I asked you to give me basically a chance to deal with the discovery issue, is from a brief in Posner, whereas my response states, frankly, when he sent me about a page-long email, and when I was reviewing this, I was in the midst of preparing for trial with Judge Meacham and everything, and my frank misunderstanding was that every discovery request issue was in the same posture. Because as far as dealing with TCPA discovery, frankly, and I'm falling. Yes, I'm falling on my sword because this is my lack of understanding. I'm not blaming any prior counsel.
I mean, I've been on this case for a few months, and you're now the second InfoWars lawyer to come in and claim responsibility for discovery problems. And I've only been on the case a few months.
And I understand that.
And I just, before you get too far into this argument, you can make it. But no, I know and I want to make it clear that I know that you're responsible for whatever any lawyer who came before you did. You had a choice about accepting this representation. You accepted it. Your schedule and the attorneys before you are not my problem.
And I understand that, Your Honor. And I'm not I'm providing a bit of context. Regardless of whatever anyone has said in the past, I have no desire to lay any blame on prior counsel. I have appeared here. I'm lead counsel here. I know Mr. Bankston spoke about Mr. Randazza. Because of the fact that his prog vitae is pending and has not been approved by this court, Mr. Randazza has frankly not been involved with these cases because of we want to keep, I personally want to ensure that we are not having someone practice in these cases where they are not admitted to practice. So I recognize that Mr. Bankston has said that, but I'm letting the court know I am the one dealing with these things. I am the one that's been brought in to try to get everything under control here, discovery-wise. The first, the biggest motion, first of all, plaintiff has now said that they want to default in all 4 cases. That's not something that's been requested in anything except the one Heslin IIED claim. So I would say that that's not requested relief that's on the board here. But regarding the Heslin, the Lewis, those 2 cases, the biggest issues that I want to point out to the court context-wise about the discovery that's at issue is that every case that plaintiff has cited for the support of their motion for their default judgment sanctions has to deal with discovery that is issued in the pendency of the regular litigation merits-based discovery. The discovery that's at issue here in those cases is only the specific and limited discovery that was allowed by Judge Jenkins. This was relevant to the TCPA motion to dismiss. It wasn't merits-based discovery. Obviously there is some overlap between what would be merits-based versus issues dealing with the TCPA motion, but that's not the full, that discovery doesn't have anything to do with the underlying merits of the claims. And so that's why we believe that it would be, extremely excessive to enter a default judgment on discovery that's only supposed to be limited and relevant to the motion to dismiss under the TCPA. Secondly, related to the discovery, I am personally reviewing 75,000 different documents to determine what's responsive. Mr. Bankston has received 6,000 of those. There's still more for me to go. I'm going as fast as I humanly possibly can. And I recognize he's entitled to this discovery. And frankly, the only other thing I want to point out about the discovery and the status of it was when I sent him an email asking him to tell me what had been produced, I had incorrectly done the search on this database to determine what had been produced. And what he didn't tell you is that 10 minutes after I sent that email, I sent him one back saying, I have it. I'm sorry. Thank you for being accommodating to me, but I have it. So I know what's been produced. I know what's been, so I know what's been produced, what's out there. But as far as the Heslin motion for default judgment, there's simply no basis legally. There's no case law cited. There's no case law that I could find that talks about granting a merits-based sanction based solely on limited discovery allowed under the TCPA. That's only supposed to be relevant to the motion itself. And so, that would be the main argument against why there would be sanctions involved here. In addition, as the council recognized, I've already worked to supplement production. I'm continuing to work with that. I've been working with my client to get these interrogatories are not simple. He says that they ask for simple information. They are not simple. InfoWars is they have had a lot of employees. They have a lot of different people involved. It requires me to get a lot of different information that I'm gathering to fully respond to these, because as an officer of the court, I recognize that there are objections that have been waived due to not, responding and things like that. So I need to give him full and complete answers. And so, that's what I am trying to do. And Mr. Bankston, he likes to file his motions for sanctions, and I understand he feels the need to aggressively pursue his case. But there's just been a lot of things stated today that are just incorrect or flat out misrepresentations to the court. First of all, the video that Mr. Bankston just played, I don't know if you noticed, but that video was spliced together from different clips. The stuff about the $1 million related to this child porn thing, that was when Mr. Jones was talking about trying to find out who had, potentially done this or put this in here. There was no accusation from them that the plaintiffs' counsel had done it. Those were just kind of meshed together. And there's other things about Mr. Bankston mentioned missed depositions. I don't have any understanding of what depositions have been missed. I recognize that there have been some corporate rep depositions for the TCPA motion to dismiss that Mr. Bankston was unhappy about the answers, and he brought those to Judge Jenkins' attention, and Judge Jenkins entered an order of contempt and a $500 fine on that. But there's been no missed depositions. I haven't received any requests for additional depositions. There's been no pushback from me on him saying he's not entitled to depositions. So I don't know where that comes from. And the last thing about this filing that occurred in the midst of a deposition, Mr. Pattis, who filed that thing in Connecticut, first of all, he didn't identify the plaintiff. He didn't actually provide quotes or transcription of the statements, but he wasn't even in the deposition. That was kind of his thing that he did. He wasn't even one doing that. But more importantly, I have nothing to do with the Connecticut.
He wasn't. That was his thing that he did. He didn't even do that. That's literally what just came out of your mouth.
I'm sorry. I didn't mean that. He did not. Mr. Pattis was not taking the deposition. He did not file the motion as he was taking the deposition. Another lawyer for the defendants was taking the deposition, and he just in the midst of this filed it. And that was, but he didn't actually do anything as far as identifying the plaintiff or anything like that. But really, and overall, the overarching point here is that there's nothing in Connecticut that has anything to do with these cases as far as the discovery is concerned. I know Mr. Bankston wants to draw corollaries between them, but the discovery stuff that's at issue in Connecticut is far broader and far more encompassing than the discovery at issue here. And so it's not a one-to-one correlation of what's there versus what should be here. Mr. Bankston also fails to mention that there's also a Virginia case where there have been no discovery issues because, frankly, Mr. Randazza is part of that case now, and discovery has proceeded orderly there. There's no issues there. They've had some slight disagreements, but there's been none of this. Connecticut and here, there's a lot of hubbub over the discovery, lots of motions for sanctions, and lots of issues there. But that's, again, I'm here to live in the present and to take what's here and to move forward and to address the problems. I have already attempted to do that by supplementing the production. I'm working to do that even more with more production. I'm working as diligently as I can to do that. I just believe that, especially related to the request for default sanctions, that would be hugely excessive considering where we stand in these cases, as far as procedurally speaking. And the fact that discovery at issue is this TCPA discovery. It's not merits-based discovery. Unless you would like to ask me questions about the default judgment motion, I can move on to the other ones.
Okay.
Right. So regarding the two motions for contempt, they're essentially verbatim. Again, I have produced supplemental document production. I have already, and again, these are not questions that I as lawyer can answer. These interrogatories, they ask for a lot of identifying information. Mr. Bankston wants to opine that I don't have any, control or contact with my client or anything like that. I do, and I'm working on. But it's not just client. It's not just like I can talk to Mr. Jones and get all this information. He doesn't know a lot of these answers related to the corporate, as far as involvement of who's doing what and things like that within free speech systems. That requires me to speak to other individuals, which I am also doing, and getting information, like I said, because what I'm trying to do is give him full, complete, responsive discovery responses so that we are done with these issues and he can move on to finding other issues. I don't want to be in a situation where I give him half of stuff and then he comes back to the court again and stuff like that. And I also recognize that he's entitled to it. And if he wants to move his expert designation deadline back because of this, I'm agreeable to that. Like I said, I'm here living in the present, trying to solve the problems that do exist, and I recognize they exist. I just don't, and as far as the contempt motions are concerned, from a purely procedural standpoint, it's unclear whether the plaintiff is seeking criminal or civil contempt findings. If they are criminal contempt findings that they're seeking, that would require actual notice and service upon the defendants themselves, not just through their attorney. So if that's what they're seeking, that would be improper at this time due to lack of due process and the required notice. And lastly, on Posner, in the response that I filed, which again, Your Honor, there was no gamesmanship involved. They're very simple responses, but I can understand, the opinion there, and I'm not really going to.
Well, I mean, you knew I wanted to read everything in advance. I wouldn't ask you to deliver it in paper if I wasn't going to look at it before the hearing.
And I can understand that, Your Honor, and that's my, and I can understand that, Your Honor. And as far as the motion for default sanctions is concerned, this is really a continuation of his December 2019 filing of it, which defendants had already responded to. I simply filed a response to their supplemental briefing. So there's already a response on file. All of those responses are indeed in box. But I just summed up the default judgment for you. With Posner, this is the first time we're here on any sort of motion to compel, motion for sanctions. I've already told, in the motion, I've already said that I recognize they weren't responded to. I place no blame and responsibility on anyone but myself for that. As far as the deadlines, I in no way would ever imply that Mr. Bankston would be responsible for keeping track of my deadlines. I took these cases on. I understand that. I'm responsible for that. And I want the court to understand very clearly that that's not the argument I'm making. I'm not making an argument beyond I'm preparing these responses. I asked the court for 14 days in my response before the court determines whether or not sanctions are warranted. We do not oppose the motion to compel itself. But what I have asked is the 2 weeks to be able to get him these full and complete answers, because there are numerous, it's more the interrogatories. I've already produced documents in the Posner case, and I've also told counsel that the defendants have stipulated that Discovery and other matters and prior production is discovery for this matter too. So he has all that discovery too. So, but as far as the requests are concerned, it's more the interrogatories that require me to gather a decent amount of information that I am actively working on. But that's really where I stand on all these motions, Your Honor, and I'm happy to answer any questions you have.
All right, Mr. Bankston, did you want to respond?
All right, yes, Your Honor, I want a brief rebuttal on that.
All right,
Let's just go down each of them. First of all, with the idea that a default was not requested in any of the motions but one, these motions are all brought under 215, and default is always one of the available options for the court when it's faced with a 215 sanction. They say that the discovery wasn't merits-based and that it doesn't address the underlying merits. There's nothing really special about TCPA discovery except that what happens is the discovery stage just vanishes, and then the plaintiff can have discovery on anything that's to the motion. The motion is to require clear and convincing evidence of every element of plaintiff's claims and defendant's defenses. So the discovery literally addresses everything in the case on liability. It just doesn't go to damages, right? So the idea, you can look at some of these other default cases in the past, and it's things like not appearing for deposition is a big one that does it. And it's not the entire case has been, every bit of discovery has been compromised, but often it's these very discrete parts. But the court says that's so egregious and it's such a thumb in the nose of the court's face that we default. Here, everything is spoiled by this. There's nothing it doesn't touch in terms of liability. They said that they produced 6,000 pages and that Mr. Reeves is going through 75,000 pages more to produce. It was my understanding that when he said he was going through the 75,000 pages, that was the 75,000 pages already produced in this case. But apparently now Mr. Reeves is saying that there is 75,000 pages of documents he is still reviewing, which is astonishing to me. Also, when Mr. Reeves produced those 6,000 pages to me a couple of days ago, he wrote to me and said, here's your 6,000 pages. We trust this is going to be sufficient to solve all of your issues of discovery. There was no indication that there was this massive trove of information that was still coming. It was, that's it, that'll solve it. Here's our 11th hour fig leaf over our completely naked contempt. Now they say there's more. He tells me the interrogatories are not simple, that they're really hard to answer. So, okay, you couldn't answer them in 30 days maybe. In normal cases, you'd probably get an extension on that. But then you couldn't answer them in 3.5 months? They're that complicated? They're not that complicated. He then talks a bit about Mr. Jones' broadcast there and that $1 million bounty was not about us, was not about the plaintiff's counsel, and that actually he was talking about somebody else. And then he just happened to be later in the same clip accusing Mr. Matei and the plaintiff's counsel of being the ones who did all this. The Connecticut Supreme Court's already rejected all of this. Has said, no, obviously, Mr. Jones was threatening $1 million bounty on the lives of plaintiff's counsel. He has unreasonably caused danger to these proceedings and encouraged people not to participate. That absolutely, and the idea that right now we're going to be trying to defend what Mr. Jones did in that video is absurd to me, but those sanctions have already been affirmed by a high court. Mr. Reeves also says that he doesn't know of any missed depositions. He only seems to know that there were some corporate representative depositions that are effectively non-appearances. But Mr. Reeves, even after my presentation, does not seem to understand that in August 31st, 2018, exactly 3 years ago today, the court issued a discovery order in Heslin that has never been responded to in any way, shape, or form. There's never been any responses to the written discovery, and there was supposed to be a deposition of Alex Jones, of Free Speech Systems, of InfoWars LLC, and of Owen Schroyer. And that's why I brought up Mr. Schroyer's arrest. It's because I'm not sure I'll ever depose him. Mr. Reeves currently does not know those depositions hasn't happened, or that discovery hasn't been answered to, on a discovery order, which he has that client has priorly been held in contempt of court. And that, again, is baffling to me. He briefly addresses Mr. Pattis in the deposition about the Hillary Clinton thing, where he was writing a motion about Hillary Clinton and was disclosing plaintiff's information. Mr. Pattis was sitting inside the deposition when that happened. But his co-counsel was taking the deposition, and he wrote up a motion, typed it on up, and sent it off to the court and publicly filed it. And that could very well happen again in this case. He then goes on to the contempt motions. And the first, again, he says that the interrogatories are hard to answer. But on the contempt motions, they haven't even tried to supplement discovery. And from his perspective, he didn't think he would have to need to, is what he was telling us. He thought that that was just about request for production and his 6,000 documents would be enough. But apparently now they're talking about going and answering those interrogatories. And I don't know if that's ever going to happen. He does offer you a solution to this contempt motion. His solution is more delay. Is that now, after all of the delay in the trial court before, all of the frivolous appeals for which they were sanctioned for, and after now just throwing away the entire summer doing nothing, Mr. Reeves' solution is, well, let's just push all the dates back and give me more time to keep doing this. That is not a solution to this case. That definitely prejudices us. His other argument is that it's unclear whether there are civil or criminal contempt being sought in this motion, but the motion is captioned motion for contempt under Rule 215 of the Texas Civil Rules. Their motion recounts that well, that we're going under Civil Rule 215. We're not seeking criminal sanctions. With Posner, his only real response there is that there was no gamesmanship. And you know what? I think I would probably agree with that, because I think in order to play a game, you actually have to care enough to play. And it was a complete conscious disregard. If you consciously disregard to this extent, you're not playing games. You're just not respecting this court's authority is what's happening. He says that this is the first time, the Posner one's the first time they've ever gotten any kind of trouble on Posner, right? But the thing is that you see all these sanctions cases talking about, you can default a party in the first instance if that instance is coming off of a long pattern of years of discovery abuse and repeated thumbs in the noses of the court. You have to understand that that's perfectly consistent with everything else they've done in front of this court. His solution on this one is that he wants 14 days. Just give me 14 more days to answer this discovery. Again, that's not an acceptable solution. He actually says he does not oppose the motion to compel. In other words, it should be granted. And if that's the case, then Rule 215 is non-discretionary. You have to grant fees if that's the case. And that's the way it is.
Do what?
You have to grant fees if that's the case. Attorney's fees will have to be granted if that is what their position is. And of course, Your Honor, that's true of every motion. Each one of these motions, being meritorious, has a entitlement to attorney's fees with it. I hadn't wanted to put more paper in front of you because I knew you were going to have a lot to review. And I honestly anticipated you'd have a lot to review from them. So I wanted to let you decide to rule first before I gave you any evidence on that. I can do that however you want. I could give you testimony now, or I can give you an affidavit and send it directly to the court, however you wanted to deal with the attorney's fees issues. But I wanted to,
I'm fine with an affidavit unless Mr. Reeves is going to want to, cross your testimony, which he can't. It's hard to do to an affidavit. So.
Right.
Your Honor, I'm happy to deal with the attorney's fees on written submission to you. If I have any issues with what Mr. Bankston submits, I will point those out in writing. We don't need to do that right now, in my opinion.
All right, then I'll include it in any orders where it is relevant, but just so it's clear and on the record now, your response will be due 7 days after Mr. Bankston files his affidavit on attorney's fees or motion or any other filing on attorney's fees.
Okay.
and Your Honor, there was one other note that I had made, just my last point I wanted to make to you on rebuttal as I had to flip the page. And this is just for when you're getting your orders and everything to understand this. Mr. Reeve just represented to you that they told us, they informed us a couple days ago that discovery for prior matters is now discovery for all matters, right? And what the court needs to be aware of is that there's a prior agreement between counsel in this case. There's a prior agreement that says, if any of the documents produced in the Lewis matter you contend are responsive to any requests in the other cases, like if there's responsive requests in Heflin, then you don't have to produce those documents again, so long as they are identified by their corresponding Bates numbers in the responses. And in here, we don't have responses. So none of that works. So it's the idea that some Lewis production would be somehow partially compliant with any of the other cases or help any of the other cases, that's in violation of the parties' agreement. So again, another small point on that. But with that, that's all the arguments we have today, and we ask you to grant the motions.
All right, thank you. I'm
Your
gonna
Honor,
take,
if I may really fast, if that's okay. I'm sorry, I don't mean to interrupt you.
well, if what you're gonna say is what you meant was they didn't notice a deposition and that's
Yeah.
why it didn't happen, what are you gonna say?
No, Your Honor, it's on these.
Then Mr. Bankston's gonna talk again.
Sure. It's just on the idea that again, he's asked for a default across the board. And, again, that's not relief he requested in most definitely in these two contempt motions. He asked for finding of contempt. And so I would just again point out that that would be far beyond what he's requested here within his motion. I realize that he said they're under Rule 15, but he specifically requested a contempt finding under Rule 15, 215. So that's
215, right?
215, yes, Your Honor.
All right.
That's it, Your Honor.
Okay, Mr. Bankston.
I don't need to respond. I think you know what you can do under 215.
Okay. All right, I'm gonna take it under advisement. I know the other case is still under advisement, but honestly, I kind of wanted to wait until we were all together again before I issued orders in that case or on the motion for Pro Hoc Vice, which is not looking good, by the way. So that's part of why I've been waiting, and I'll get this to you pretty quickly, as quickly as I can.
Your Honor, just one brief point on the Pro Hoc that you mentioned. Again, I do want to mention to you that Mr. Randazza is involved in this Virginia case where ever since he's been involved, this discovery has gone fantastically there. It's been dealt with accordingly. It's been dealt with in an orderly fashion. Mr. Bankston has previously told me that he thinks that my client has tons of lawyers working for him in this case.
Well, he's allowed to, that's fine. But the question is, does that attorney get to appear in this courtroom? And that's a separate question. He can work on anything somebody properly hires him to work on behind the scenes. That's different. Somebody wants to take a chance bringing a lawyer in who's not licensed in this state to give advice on what to do in this litigation. They have the right to do that. What they don't have the right to do is have him appear and represent for him in court. I get to decide whether he does that or not.
And yes, I understand that, Your Honor.
Okay.
100%.
Your Honor, I had one question about that. Mr. Randazza likes to email me and do stuff on this case. I don't feel like I have any duty to have to deal with him. I don't know if it's fine with you for me not to want to deal with Mr. Randazza, but to deal with Mr. Reeves instead.
Well, Mr. Reeves, as he told us today, is lead counsel for these cases, is the only counsel of record filed with the court that I'm aware of, right, Mr. Reeves?
That's correct, Your Honor.
So I guess Mr. Randazza could email similarly to how an associate of Mr. Reeves could email and be speaking for Mr. Reeves if Mr. Reeves allows him to do that. I would suggest that that information be written down.
And Your Honor, as far as I know, there's been no direct communication between Mr. Randazza and Mr. Bankston without me involved. It's more the issue of I have included Mr. Randazza on emails as a CC, and he has responded sometimes, but it's not like it's not like just Mr. Bankston's dealing with Mr. Randazza. I'm involved because this is, like I said, I'm lead counsel. I take that very seriously in these cases, especially given their history. I take it very seriously what's going on here and what I'm dealing with. And so, I want the court to understand that and be aware of that. But that's what Mr. Banks is referring to, is that Mr. Randazza has been included on emails and has responded to some of them, but it's not solely Mr. Randazza doing things without me knowing or being involved in these
So
matters.
you're telling me that Mr. Randazza is speaking for you in those communications?
The only communications that he has spoken for me about was dealing with sanctions that the Court of Appeals had rendered on a prior appeal of where they determined the appeal was frivolous, that hadn't been paid, that we were working out details of how to pay that. That's really it. But everything else, I'm not trying to capitulate.
Your response reminds me of a depot transcript I listened to earlier. So
I'm trying to answer your question.
The question was, what you're telling the court is that when Mr. Randazza sends an email, it's on your behalf and he's speaking for you. Is that right?
If if it involves these Texas cases, I will say yes, Your Honor.
Okay. Does that help, Mr. Bankston?
Sure, that'll help for now.
All right.
One other thing I wanted to bring up with Your Honor, I don't know if this sounds like a good idea to you. Obviously, these cases require more judicial babysitting than maybe other cases have required in the past.
Definitely learning that.
Yeah. So in Lafferty, they have come up with a system of where they're actually having monthly status conferences to just make sure everything's working. I don't know if you want to schedule our next meeting together or how you may want to do that. I certainly know I'd be willing to do something like that.
I mean, it's probably not a bad idea.
And you know, there may be cases where you say, hey, do we need to have a status conference this month? And both parties say, nope, everything's swimming smoothly. We don't need to, or whatever. But something I thought I'd throw out there.
I think I mentioned at the conclusion of the Fontaine hearing that I had some second thoughts about our trial schedule. Mostly, I think just for the toll it would take on this court to hear those cases in such rapid succession, assuming that after the first one or two, the rest don't settle, which I would love to sit here and say, looking at it rationally, this is what I think will happen. I just don't know how helpful that kind of examination of what should happen will be in this case, given the personalities and the subject matter and the emotions involved. So I don't think I'm not comfortable setting a schedule for this court that assumes what happens in the first case will affect what happens in the remaining cases. Does that make sense?
It does.
Okay, so it is my plan to take another look at those schedules and make some changes. I think I mentioned already, one of them was like a backup setting, and we are not going to trial that week. So I haven't issued an order, but I've let you guys know that there's not going to be a trial that backup setting week.
One thing I should probably let you know, if you're going to be thinking about trial settings and that sort of thing, is that our decision about how to go forward on these cases is probably going to be heavily affected by the outcome of this motion.
I would assume.
And so what I would say to that is just to give the court a heads up that this is what we'd be intending to do it. And I'm giving defendants counsel a heads up too, that if the disparate liability issues are sort of taken out of the case through a default, and there isn't the possibility of jury confusion over the liability issues,
You're going to seek to consolidate.
all of them for damages. It's the only thing that makes sense under that situation, because then you don't have the potential jury confusion of those ideas. And then you're only looking at one trial. So I think to make some of these decisions, it's going to have to know what happens in this motion first.
Yeah, okay, thank you.
Mhm.
Okay, well, I think that's it. I'm gonna take that under advisement. I've got your suggestion, Mr. Bankston. I'll let you guys know, Mr. Reeves and Mr. Bankston, I'll let the two of you know if I'm gonna set this for some kind of regular schedule. At a minimum, we will have another schedule to discuss the schedules, so.
And you're just the backup setting you're talking about is, do you know if it's the April 25th setting that you're referencing?
I don't know. It's
Okay.
when you look at the list, it
Mhm.
clearly says backup for another
There's
case.
two on the same case. Yeah, there's
Right.
Posner and Lewis are set at on the same date, and that's kind of what I figured. I just wanted to make sure I had that correct understanding.
I wouldn't worry about it too much in general, because we're gonna address those again. And I also know there are a number of, I think anyway, that there are several other motions pending that were not set for today. So we're gonna have to have another hearing anyway on those, right? So when we ended Fontaine with a possible agreement on confidential records, I don't think I've seen that agreement. Don't talk about it because he's not here. I don't want to make that mistake again. But we had also discussed wanting a similar agreement or order in these cases. So I haven't seen that in any version, so I expect that's coming.
I'm glad you brought that up, because we probably need to set a hearing for that, Your Honor.
Right, that's what I'm saying.
Yeah, because I'm going to be getting records soon, I'd assume. And yeah, we were able to reach agreement in the other case, but here.
Oh, do I have a copy of it? I don't think. I
Yeah,
have a copy.
that's been filed. Again, I'm not going to go into that.
So remember, Mr. Bankston, when you file something, I don't get it.
Right, it actually wasn't us who filed it. I'd assumed that he had provided it to you. I guess he hasn't.
He
So
should know even better than you that I don't get it because he works in Travis County.
He's
Right.
talking about in the Fontaine matter, Your Honor. That hasn't happened in this case.
Yeah, I'm
I
talking about.
understand.
Right.
Okay, just make sure.
In this case, Mr. Reeves opposes a protocol for in-camera review. Has said he wants to subpoena the records himself, not have an in-camera review. So.
Okay, well, you can set that for a hearing, but you're gonna lose that one because these are sensitive records and we're not doing that.
Okay, and that's, I appreciate that. And what I'll do with that, I'll retrace and I'll talk to Mr. Bankston about it. It had more been, honestly, Your Honor, the idea that plaintiff was going to be the gatekeeper of what was going to be submitted in camera. And
Right,
thank-
that, so there, he's not the gatekeeper of what's submitted. He's the gatekeeper of what is not submitted in camera. And that's standard. We do this all the time for medical and mental health records in every kind of injury case you can think of. So the plaintiff gets the records, goes through them, says, you can have these. If you want these, we're gonna ask the judge to look at them first. That's super standard.
Sure.
If you oppose that, that's not gonna go well. You're gonna have a very hard uphill road convincing me that there's some reason what works in every other case I get won't work in this one.
And I understand that, Your Honor, and I want you to know, I am in no way, I have no desire to waste the court's time with things like that, especially given now what you've said here. I've used that process many times. I represent, I have personal injury clients and things. I understand the process. It was just that the way that Mr. Bankston and I discussed it, it was, to me, did not comport with that process. But again, I will, especially given what you said, I'll revisit it with Mr. Bankston. I'm sure we can come to an agreement so that the court doesn't have to waste their time dealing with that. I have no desire to have the court deal with things that we as the parties should be able to figure out.
Great. So when you reach that agreement and you execute it, send me a copy. Don't just file it with the clerk.
Yes, Your Honor.
Okay, thank you. That's gonna conclude the hearing. Everyone's excused and I will get with you as soon as possible.